I'd have to say it's a project in progress still. Some years we've had a bigger number, and other years not, and has more to do, I think, with the nature of the cases than anything else. I still think it's an important objective. One, because I think judicial decisions should be narrower rather than broader, and the way to do that is to try to get as many people on board as you can. That if you're going to reach a broad decision that's going to cover all sorts of different factual scenarios, a lot of people are going to say, well, whoa, I'm not quite sure I agree with that, and then they might write something narrower. But if you keep it narrow, that it only decides what's absolutely necessary to be decided, usually you can get more people to agree with that. One of our most important decisions, Brown versus Board of Education, is a perfect example of that. Earl Warren worked extremely hard to get everybody on board because he wanted it to be a unanimous decision to send a clear message to the American people that we're turning a page as a matter of law. And he was able to do that. And a lot of lawyers and even judges don't appreciate this, but the opinion in Brown versus Board of Education was, I think, 11 pages long. And Warren said, if he'd written one more paragraph, people were going to start splintering off. You pay a price for that, and you did in Brown as well, which you have a lot of issues in the area that aren't resolved and need to be, spend in many cases a generation resolving. But Warren thought it was more important to keep everybody together, and as a result wrote an opinion, while revolutionary was, in its own terms, really narrow.